Important topics of the day. This program is for critical thinkers. And now, here's your host, integrated media professor, longtime Spokane Talk radio personality, and award-winning broadcast veteran, Mike Fitzsimmons.
I welcome you to this edition of For Critical Thinkers. I'm Mike Fitzsimmons, and today our topic is a timely one. It's going to be packing the United States Supreme Court. Packing the court. House and Senate Democrats want to materially change the nation's highest court. We're going to talk about how they tried to do it or plan to do it, and we'll discuss the pros and cons of that issue as well today, and the probability as to whether or not they can carry it out. So now, if you want to participate in this show live today, here's how you do this. If you want to join the conversation, you send an email, as you see on your screen, to sam@SpokaneTalksMedia.com. Sam's going to send you a password. This will be a numerical password, and you will be able to then enter that password, and you can then talk live to me. If you happen to have a camera and a microphone on your Mac or on your PC or on your telephone, which many of us do have, of course, that'll allow you to be seen as well as to be heard, and we always welcome the opportunity for you to do that. So if you want to, that's what you do. Sam@SpokaneTalksMedia.com. And we want to thank our alternate benefactor, our sponsor on the program, who is Stephen Major. I've always appreciated his enthusiasm for this show and thank him very much for that. The support of Stephen Major is certainly critical because it makes this program possible. This is what we call For Critical Thinkers, and there is a definition for critical thinking. And here it is. It's the objective analysis of and evaluation of an issue in order to form a judgment. Now, what does that mean? Well, it means you have to be objective. Not just your opinion that counts, it's what you actually know and can prove. It's an analysis. You have to do some verification. It's an evaluation. You have to come to a conclusion about these sorts of things and form a judgment about them. That's what critical thinking is all about, and we try to do that on the issues that we take up on this particular program, because very often people just don't seem to have a good understanding of the facts about things. That doesn't prevent them from having an opinion, but they don't have a good understanding of the facts, which means that whatever opinion is formed is highly likely to be erroneous. So, packing the United States Supreme Court. That's our topic, packing the court. Democrats have threatened to do this for quite a long time. And now, as of this date, which is the 15th of April, as we go on the air, there was a press conference this morning in Washington, D.C., in which Democrats, leaders of the House and Senate, came forward to advance a new two-page bill that would essentially change the makeup of the United States Supreme Court and greatly benefit the Democratic Party. They have threatened to do it for a long, long time, and today they said we're going to expand the court. They had the press conference at the staircase to the United States Supreme Court, and in the process of doing so, they said that among other things, they were going to right some wrongs that were caused by the Republicans. Progressive Democrats in the House and Senate, and here are the four top ones who were involved in this process. Progressive Democrats in the House and Senate want to expand the Supreme Court to 13 seats. They want to expand the bench to 13 seats. Jerry Nadler and Mondaire Jones in the House of Representatives, and Ed Markey from the state of Massachusetts, and Hank Johnson in the Senate want to introduce a similar bill. Now, what they claim is that the expedited nomination and the confirmation of the latest appointee to the United States Supreme Court, Amy Coney Barrett, last year by Donald Trump was a case of stealing a seat. Stealing a seat. That's a lot of rhetoric, but it is also terribly inaccurate. You might, if you are convinced by rhetoric, buy that at face value, but if you do, you're a fool. You see, what that rhetoric about the Barrett appointment is all about is that it conveniently leaves out the fact that she was nominated to fill a vacancy, not added to the existing court, but there was a vacancy, the death of Ruth Bader Ginsburg, as you know. And the proposed law that they put forth today would add four new seats to the court. 4 new seats to the court, where, as we speak, no vacancy currently exists. So we go from 9 to 13 members of the court. A little bit of history. The United States Supreme Court was established by the United States Constitution, which at the same time also established the executive branch, the legislative branch, and the judicial branch. In Article 3, Section 1 of the Constitution, judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. What that simply means is there'll be one Supreme Court. That'll be the final say as far as law is concerned. But as the United States expanded from the time of the adoption of the Constitution in 1789 to the present day, we went from 13 original states to now 50, and there's some talk about a 51st or a 52nd as well. But in any event, the courts, the lower courts, the appellate process went from a single district to 13 districts, and now, of course, all states are in one of the 13 districts. And Article 3, Section 1 set up the process by which the Congress of the United States, in its wisdom, could decide exactly how many lower court systems there would be. And, of course, also that included the federal court of original jurisdiction process as well, and a number of other courts, including tribunals and military courts and that sort of a thing. So what does the U.S. Supreme Court have as its power base? What's its powers? Here they are. Let's look at them and talk about them for a moment here. 1, to interpret the U.S. Constitution. That's to decide whether laws or government actions are in fact consistent with what the majority of the justices on the court believe to have been the intent of the founding fathers, the Constitution's language itself. Judicial review, which is to review cases where the lower courts have differed about the outcome. To interpret laws and to ensure that they are constitutional, that's what the court does, to ensure that laws are faithfully applied, and to rule on cases involving the Constitution, federal laws, treaties, and disputes between citizens of various states and between the states themselves. Now, how does a case get to the Supreme Court? It gets to the Supreme Court by what is known as a writ of certiorari. And a writ of certiorari simply is this. It is a call forward from the high court to send the issue, the case, the litigation up, send it up to them. Now, there is a criteria, 3 actually, criteria that are involved in this process, and the Supreme Court has the discretion to determine what cases they will hear and what cases they will not. And in any case, if they decide what cases they will hear, it will be because that particular case or issue has satisfied the 3 criteria for certiorari. 1, it must be of a national importance. And a national importance typically is identified as having a constitutional impact. In other words, a constitutional question. Must have been some disagreement in the appellate court level. Now, I mentioned 13 districts for the appellate courts. Those 13 circuits, they're called, those 13 circuits are actually designed to serve a certain number of states by population. The Ninth Circuit Court of Appeals, for example, and you've heard that language many times in this part of the country, happens to have its headquarters in San Francisco. And if you live in the states of Alaska, Washington, Oregon, Idaho, or Montana or California, you would go down to San Francisco to have your case appealed in the federal court system. And that decision that is made in that federal court circuit would only apply to those states that are members of that circuit. It would not apply to any other states in the United States. And so what the Supreme Court does before issuing certiorari is to see how other courts in other parts of the country and other circuits have decided the outcome of a particular litigation where the case in point is the same. And when they do that, there has to be some conflict at the appellate level before certiorari will be granted by the Supreme Court. So a federal question, a constitutional question, and disagreements at the appellate level. And lastly, the third leg of that criteria is that the litigants must have exhausted all other legal remedies before the United States Supreme Court will take up their case. In other words, there isn't any place else they can go. This is the court of last resort, and if it doesn't take the case, the litigants are out of luck. The petitioner is out of luck. The Constitution establishes the Supreme Court, but it also authorizes the Congress of the United States to decide how to organize it, and that's central to note that. Let's look at that. The Constitution of the United States establishes the Supreme Court, but it also authorizes the Congress to decide how to organize it. We have a slide that states that.
Hey, Mike,
and it is within the legal authority of the Congress, but it is the right thing to do that really matters. In other words, the United States Supreme Court takes the position that if it ain't broke, don't fix it. The Constitution says nothing about how many justices must be on the Supreme Court. And over time, that number has actually started out with 6 justices, expanded to 7, and has gone as high as 10. I see a note that we have an incoming question. Let's go to that.
Well, Mike, we have a question from a Summer. She is wondering what you think about Mitch McConnell not letting Obama appoint a Supreme Court justice because it was, quote, too late in his term, yet Mitch McConnell was all for Trump replacing Ruth Bader Ginsburg, even though he had 2 months left in office, and her literal dying wish was that that wouldn't happen.
Well, I want to get to that. I want to do a whole section on that. So, Summer, if you'll hang in there with me, I'm getting to that. I want to lay a basis foundation first of all, and the reason I want to do that is that a lot of folks don't understand how the whole process works to begin with, and why there was a controversy over that. That's a very good question, and I will address it in detail. But let me just progress if I can, okay? And then I'll get to that question in due sequence here. So the Constitution establishes the Supreme Court, and it also authorizes Congress to decide how to organize it. And the Constitution says that it says absolutely nothing about how many justices there must be on the Supreme Court. Indeed, over time, there have been a different number. Numbers fluctuated. The court started out with 6 justices, for example, expanded to 7, went as high as 10. Congress set the Supreme Court at 9 justices clear back in 1869, shortly after the Civil War in the United States. But if a president and the Congress agree, they could change the number, expand the court, even shrink the court. So anyone who wants to suggest that it's illegal or unconstitutional to change the number on the court would be wrong. It is perfectly constitutional. It is indeed provided in so many words in the Constitution of the United States. Let us first understand how a Supreme Court justice is appointed. Many Americans don't know how a U.S. Supreme Court justice is nominated and appointed. First, there has to be a vacancy. There has always had to be a vacancy, a death, a retirement, or a removal by impeachment. The United States Constitution, in Article 2, Section 2, authorizes the president to nominate citizens to fill vacancies on the federal judiciary, and instructs the Senate, just the Senate, not the House of Representatives, not Congress as a whole, but just the Senate, the upper chamber, to provide advice and consent for the nominee's confirmation, to ensure an independent judiciary, and to protect judges from partisan pressures. The Constitution provides that justices serve during good behavior, as the Constitution meant or relates. Let's move to the next slide, if we could. To ensure the independence of the judiciary and protect justices from partisan pressures. So I think we're out of sequence a little bit here. There we go. All right. Good behavior has been defined basically as generally life terms. So a justice to the United States Supreme Court, a justice on a lower court, an appellate court, and even a judge in a court of original jurisdiction serves for life. Now, since justices do not therefore have to run for campaign re-election, they are thought to be insulated from political pressure when deciding cases. Justices may remain in office until they resign or pass away or are impeached and or otherwise convicted by the Congress. Well, they may think that they're insulated from political pressure. The bottom line is politics have always been a part of this process. Not necessarily within the court, but not always removed from within the court, but very much so in the nomination and confirmation process. From the beginning of the Republic, presidents have picked justices for reasons that include balancing regional interests, for example, which would be a political objective, supporting policy priorities, providing representation to key constituencies. So in other words, the selection of the candidate to become a justice of the United States Supreme Court has very often been a political driver, if you will, a political purpose to be satisfied by doing that. The Supreme Court, remember, is a co-equal branch of our government. The Constitution sets up three branches of government: the executive, the legislative, and the judicial. It is not, the court is not, a lesser branch, nor is it required to submit to either the executive or the legislative branches. A lot of folks don't know that. A lot of folks don't realize that that's the reality of the way things are structured. The Supreme Court, despite its decisions that have had substantial political impact, has thus far, at least, managed, for the most part, to keep its independence intact. But history is full of Supreme Court appointees who have not been what the presidents who nominated them and the Senate that confirmed them thought that they were getting in terms of legal decisions. There is an interesting thing that happens, and it has been observed by a number of members of the United States Supreme Court over the last number of decades, which is that once an individual whose credentials and whose background and what have you is picked for the court, that individual, once they get on the court, tends to ignore the political foundations that resulted in their appointment in the first place. And usually, not always, but usually, will focus more and more on the constitutional process and reality of the legal question at hand, as opposed to the political desires or political objectives that the president that appointed them or the Senate that confirmed them desired for them. So they change. Their spots get different. And that is of great frustration to the people who put them on the court in the first place. But if that were not the case, then the court would be nothing but a political tool for the folks who are in power. Here are the 9 current justices of the United States Supreme Court. And I've circled there by color, if you will, red or blue, which is not necessarily Republican or Democrat, but probably more representative of it being conservative or liberal on the court. And as you can see, there are 6 circles that are in red, 3 circles that are in blue. Does that mean that always those 6 cast their vote for the conservative view of a particular law, and always those 3, they're circled in blue, tend to cast their vote on a court case on the liberal side? The answer is no. But the balance of the court is necessarily said to be 6-3 at the present time. And 6-3 is in favor of conservatives, theoretically. It's not actually necessarily the truth. 6-3 may be the balance on paper, but the question becomes whether or not the justices of the Supreme Court actually act consistently and always in the line of conservative or liberal in their decision making. And the answer to that is no, they don't. The 6 Republican appointed justices do not always take a conservative position and have not always taken a conservative position. But interestingly enough, historically, Democratic justices who were installed by Democratic presidents almost always take a liberal stance on the court. Seldom break with the party expectation, as it were. That doesn't mean that the Republicans, when they put a justice on the court, don't realize or understand what this particular judge or attorney, as the case may be, what their particular position is or view of constitutionality and such. It's not that they're making a mistake about it. It's that they've given them, and all of those who are appointed to the Supreme Court are given, the power, the freedom to decide cases based on their merits and the constitutionality thereof, and not based on the expectations of their nominators or the ones who have confirmed them. Here's an example. Chief Justice John Roberts. He was appointed by President George W. Bush. And he's often taken legal positions that have disappointed, perhaps a better word yet would be confounded, conservatives. One of the major positions that he took, for example, was to conclude that in the Obamacare law, that the penalty was a tax. It was never intended by the drafters, the Democrats who drafted it, to be a tax. It was intended always to be a penalty. But here's a case of the judge not only interpreting the Constitution, but essentially changing a statute to reflect an opinion of his that wasn't even the Congress's opinion at the time in which the law was passed. And 2 recent appointees to the Supreme Court, Justices Neil Gorsuch and Brett Kavanaugh, both Donald Trump appointees, have also been quite unpredictable in several rulings that caused significant angst, you can be sure, for conservatives, and certainly disappointed the president who appointed them. I mentioned earlier, and I'll mention this again, there have been 9 justices on the United States Supreme Court since 1869. That's when the number was established. And so we have to ask the question, here we are in 2021, why has packing the Supreme Court resurfaced as an issue now? Why? We'll take a time out here, and when we come back, we'll discuss that question.
Hi, my name is Liam, and I'm 6 years old.
Liam was diagnosed with cystic fibrosis at pretty much at birth. With Liam having to do treatments, breathing treatments every day, it's very worrisome because around our area there's a lot of fires and then there's harsh weather. So there was a day this summer where we were out of electricity. I want to say 5 in the morning till maybe 5 in the afternoon, and it was very hard for me not to have electricity because, I mean, we couldn't do his treatments. We spoke to Wishing Star and they were able to get us a generator, which was a really big stress relief. Anything could happen any given moment. We will be able to do his treatments and clear his lungs, even if there's fires or any kind of weather. For the donors of Wishing Star, I don't know where would we be, without them, with this donations that they do for us.
Ella was diagnosed with pretty rare cancer, metastatic Ewing sarcoma. Ella was 20 when she passed. I didn't know much about Wishing Star, and we got to know them quite well. They came for regular visits. Just mostly we got to know Ella and spend time with her and find out what her interests and what she liked to do.
We had a lot of support, having had them kind of with us through the whole situation. We knew that they knew what it was like for us. They were just really wonderful.
Even for after Ella passed away, and just helped out tremendously. They were like our right hand, just helping with flowers, and we even trusted them to, take her urn and move it from the funeral to the reception, things like that. Wishing Stars stayed connected with us, and that's meant a lot to our family.
Welcome back to For Critical Thinkers. I'm Mike Fitzsimmons. We're talking about packing the Supreme Court, or legislation that would achieve that. So the question has come up, why has packing the Supreme Court resurfaced now as an issue? Well, as I mentioned at the outset of the program, Democrats have been stinging ever since the situation involving Merrick Garland during the Obama administration, the final year right before the election of 2016, and the Amy Coney Barrett appointment that occurred in 2020. And they have been very, very upset about this situation for a long time. At the outset of the program, I mentioned that the Democrats believe that Donald Trump, and with the help of Mitch McConnell, who was at that time the Senate Majority Leader, and set the Senate schedule and the laws and or debates that they would have. In the case of Merrick Garland, the Democrat nominee by Barack Obama in 2016, it was in the same year as the election, did not get a hearing, with much criticism for Mitch McConnell. The reality is he held up that hearing for a number of months on the theory that there shouldn't be a determination by the Senate, would leave it up to the election that was coming up in 2016 as to whether or not the people wanted a Republican to nominate that vacancy or a Democrat to nominate that vacancy. That was the vacancy caused by the death of Anton Scalia. That was several months. And that was basically under the expectations established by Senate rules. Now, was it a political move that resulted in the president's nomination of Amy Coney Barrett last year, right before the election? And I mean right before. This wasn't several months before. It was only about a month and a half before the election that the death of Ruth Bader Ginsburg took place. And President Trump immediately had Amy Coney Barrett in mind to replace the longtime icon of the Supreme Court, Justice Ginsburg. The Senate rules are not constitutional rules. They can be set and changed by the Senate majority, and they are often done that way. Go back, for example, just prior to the Republicans taking over the control of the Senate. And you had Senate rules having to do, for example, with the 50+1 determination for passing legislation. It had to do particularly with financial issues, tax issues. And that's how they got the Obamacare through. Harry Reid, who was then the Senate Majority Leader, changed and got the votes because he had the majority to change the process in the Senate rules, suspend them so that by a process that is highly unusual when it comes to such a thing as an insurance program, like, for example, Obamacare, by reconciliation, the Democrats were able to pass the Obamacare law, a massive law affecting some 20% rather of the American economy, and they did it without a single Republican vote. So there is shifting now and then based on political objectives of the powers that be that result in weeping and gnashing of teeth for the folks who don't have the majority. And that's exactly what happened in this particular case. Was the change a completely political one? Yes. Was it also lawful? Yes. And did the Democrats, when they decided to leave Merrick Garland's nomination alone, because they actually expected they were going to win the election, they expected that Hillary Clinton would do the nomination and that she would win by a landslide, which did not prove to be true. And I think that what you had was a situation where the president, at that time, Donald Trump, realizing what happened in the Garland situation, basically convinced McConnell to change the Senate rules because they had the majority to be able to do that. They did it, and then he made the appointment, and then they confirmed Amy Coney Barrett. Now, was that a political machinization? Sure it was. No question about that. No question at all. Was it exclusively a Republican thing? No. Democrats do it all the time and have tried to and will continue to try to do this very session. So I don't really have a tremendous amount of sympathy. When you have an advantage, you use the advantage. That's the politics part. That's the politics part. As far as the one who was appointed, Amy Coney Barrett was appointed because she is believed to have, or was at the time in which she was appointed, believed to have conservative views with respect to the law, be a strict constructionist and such. It remains to be seen as to whether or not she actually is going to rule at the court in that very way. Well, now Democrats are the party in power. Democrats are. And Democrats, as you may recall, filed many lawsuits during the Trump presidency. Almost every major policy action taken by Donald Trump were challenged by the Democrats in one or a number of the federal courts. Lawsuits get filed with respect to the actions of the federal government. And opponents to the Democratic agenda will seek legal rulings on the constitutionality of the things that Joe Biden does. And so therefore, in order to not become the victim of legal hang-ups, tie-ups in the courts, which keep policies from being implemented, as the Democrats became very good at doing during the 4 years of Trump, Democrats now need a cooperative Supreme Court to rubber stamp their ambitious agenda. Democrats are the power that be, and they need a cooperative Supreme Court to rubber stamp their agenda. And thus we have an attempt to add 4 more seats to the court. Now understand the difference between that and filling a vacancy. There is no vacancy on the Supreme Court. There are 9 justices on the court as we speak. The Democrats want to add 4 more. They want to change the supposed balance of the court from 6 to 3 favoring conservative, obviously, to 7 to 6 favoring the liberal. That's what they want to do. That's their objective. Adding more justices means making the court a political tool of the party in power. And unabashedly, that's what the Democrats plan to do with this particular law they want to introduce. They want to make the court a political tool of the Democratic Party in power. And the Democrats plan to establish single-party rule for the foreseeable future. They have a aggressive agenda, aggressive progressive agenda. They want to establish single-party rule for the foreseeable future. And what does that involve? Next slide, please. What does that involve? Next slide after that. I'm sorry, I got out of sequence here. No. Back them up. There we go. Adding more justices. That's what we're looking for. The slide that says adding more justices means making the court the political tool of the party in power. Democrats want open borders. They want a major tax increase. They want abortion on demand. They want limits on personal liberty. They want gun control. They want to diminish property rights, and a federal property grab is going on. They want to relax voting rules. They want the Green New Deal, unrestricted immigration, amnesty and statehood for for immigrants who are in this country illegally, and they want statehood for D.C. and Puerto Rico. That's pretty aggressive. That's what they want to do. That would materially change the makeup of the United States. So the question then becomes, how do they want to do this? Well, they're going to need a Supreme Court that will essentially approve that objective, because they know that the Republicans will do what they did while Donald Trump was in office, and that means sue the federal government, seek injunctions, do all kinds of legal maneuvering to try to stop certain things from happening, because the Republicans do not have the majority and can't overcome it legislatively. So packing the court becomes a way in which to accomplish this. Joe Biden is president of the United States now. Back in 1983, when he was on the Judiciary Committee, Joe Biden had a very different view of packing the court than perhaps he harbors this day. Biden said back at that time that it was a bonehead idea for Franklin Roosevelt to try to do a similar thing, which was to stack the court. In 1983, he said it was a bonehead idea, a terrible mistake, to put in question for an entire decade the independence of the most significant body, including the Congress of the United States, in his view, the most significant body in this country, the Supreme Court of the United States of America. Question is, has Biden changed his spots? Well, he has taken a position that's rather interesting. It isn't an attempt to campaign for more seats on the Supreme Court. He has rather formed a commission to study the policy of packing the court. The commission was announced last Friday. And here is the purpose of the commission. The commission's purpose is to provide an analysis and the principal arguments of contemporary public debate for and against Supreme Court reform. That's what we call it. Rather than packing the court, we just simply call it reform, which is, of course, a word that is filled with a variety of meanings. And that commission will also include an appraisal of the merits and legality of the particular reform proposals that come from it. No concluding recommendations were asked for by Biden, by the way. And so no action is going to be indicated when the study comes to an end. The commission will be bipartisan and will be comprised of politicians, of jurists, legal scholars, people from academia, and ordinary citizens. And the commission will complete its work in no more than 180 days. Now, it's not a surprise, it should come as no surprise, but if you look at the list of likely members that have come to surface so far in the commission, you find that it reveals a strong liberal and progressive bent. Not a surprise, I would expect that. Naming the commission may be an indication, however, of Biden's lack of enthusiasm for court packing. Naming the commission buys the president 180 days, as I mentioned, 180 days. But he hasn't even asked for a recommendation when that period is finished. And if that's the case, no action is therefore going to be indicated. President Biden is essentially buying time. And buying time allows him to see what, if anything, happens that changes perhaps the way the political winds blow. He could become stronger toward court packing or not interested. Looking at history, there was only one serious attempt to pack the court in our history thus far, and it occurred during the Depression and during Franklin Roosevelt's New Deal. Franklin Roosevelt tried to add justices to the Supreme Court back in 1937. The Washington Post published this following headline: Roosevelt asks for 6 new high court justices. 6. The current law introduced just today is asking for 4. He wanted 6. And Roosevelt pushed this ill-fated Judicial Procedure Reform Bill of 1937, where essentially everybody who would be on the Supreme Court would be just yes men for the president, so to speak. But the Congress didn't go for it. What gave rise to this whole situation was that a number of the provisions of the Roosevelt New Deal got tied up in court. As you might imagine, these were very, very aggressive legal changes that resulted in political opposition, that resulted in lawsuits filed, court hearings followed after that, and the bottom line was that the Supreme Court did not rule favorably to the Roosevelt administration on several of these particular provisions of the New Deal, and Roosevelt was upset about it. He was looking for a way to get around that, and the way to get around that, he thought, would be to pack the court. Here's a cartoon that appeared in one of the newspapers. Yes, 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 all vote yes. In other words, Roosevelt's guys would be on the court, which is the antithesis, if you consider it, for what the court ought to be. And for FDR, it resulted in a significant, a substantial political capital loss over his court packing theme, his scheme to try to load the court to 14 justices from 9. Now, we have this effort to expand the court coming up, and I'll talk about that, the current law and what people's positions are on it. And you may be surprised. I don't think that the Democrats will allow court packing to happen. We'll be right back.
The Wishing Star Send a Friend a Goat fundraiser is back. They are adorable, snuggleable, and hilarious. For 16 years, baby goats have brought joy to thousands while raising essential funds for the Wishing Star Foundation, which grants wishes for children with terminal and life-threatening conditions while supporting their families long after the wish. From May 3rd through the 7th, you can have a baby goat delivered to a friend, family member, boss, or coworker. The Wishing Star Goat Wrangler volunteers will deliver an adorable live baby goat directly into the arms of your recipient. For a $60 donation, this is a fun and lighthearted way to get some laughs and support the Wishing Star Foundation Wish programs at the same time. Place your order today at wishingstar.org/goats. Happy goating!
My story is written on my body. My mom died when I was 12, and I never knew my dad. The gangs became my family. After being in and out of prison, I prayed, please help someone see me for me, not my past mistakes. And that's what I found at the Union Gospel Mission. Now, I work at the UGM thrift store, and I finally have the support to be the dad I want to be. Real people, real change. Union Gospel Mission.
Welcome back to For Critical Thinkers. I'm Mike Fitzsimmons. Just today, the Democratic leaders in the House and in the Senate, some Democratic leaders, I should say, stood at the steps of the United States Supreme Court and offered new legislation to be heard both in the House as well as in the Senate to expand the number of justices of the United States Supreme Court from the current 9 to 13. So how is that flying today in Washington, D.C.? Nancy Pelosi is the Speaker of the House, and she isn't buying it. She's not too excited about the idea. She said that she has no plans to bring this bill to the floor. She favors the Biden Commission approach to things. She said she doesn't think that it's unnecessary to have the conversation, but she doesn't like the way the bill is written, and she says that she will not bring it to the floor of the United States House of Representatives. And on the Senate side, the Senate Majority Whip, Dick Durbin, says he's not ready to support this bill. And he has been saying that for quite some time. He doesn't like the language in this bill. He doesn't like the fact that it is not replacing a vacancy on the court, but adding seats that will be seen as a bold attempt to change the balance of power on the court to favor Democratic legislation, and that the public will not be patient with this. In fact, he's concerned that in the upcoming 2022 elections in the Senate, which 34 senators are up for re-election, that they will probably lose the Senate majority and could very well over this. Nancy Pelosi is nervous about that with respect to House seats. As you know, the Senate majority isn't a majority at all. There's a 50-50 membership. And the only time that the Senate has a majority is if there's a tie. And that would mean the Vice President, Kamala Harris, would then break that tie. So at this point, there's a lot of political jeopardy involving this situation. In the Senate also, you have the new senator who won in the state of Arizona, Senator Kristen Sinema, who's a Democrat out of Arizona, who said, I will not support any effort to pack the United States Supreme Court. And that's what this will be, an effort to do that. So if they're not going to back it, it isn't going to happen. But also there is one other thing to concern yourself with, and that is that in order for the Senate to even take this up, given that we have the cloture rule of 60 senators out of the 100 who must favor bringing it to the floor, the Senate must first abolish the filibuster. Now, that's another issue altogether, but suffice it to say that the filibuster has been there for a long, long time, and if you strike the cloture of 60 and make it 50 plus 1, then with Kamala Harris as the tiebreaker, the Democrats would have the ability to run the gamut with respect to their political agenda. And unfortunately, that's not likely to happen either. And that's because of this guy, Senator Joe Manchin, the Democrat from West Virginia. He says he does not support court packing, and he does not support ending the filibuster. So if he's going to remain firm on that, and it appears that he is. He ran on it. He got reelected this last time. And if he is going to remain firm on that, then the senators will not have a 50-50 tie. They will lose by one vote, and Kamala Harris won't be able to save them with respect to the filibuster. In which case also he says, I don't support packing the court, and that would require, of course, 60 votes. That would mean Republican votes would have to join the Senate Democrats in order to make it possible to get to the cloture of 60, and that is unlikely to happen as well. And then we have the words of a sitting liberal U.S. Justice of the Supreme Court Justice Stephen Breyer. And he has just spoken, just within the last few days, and basically has said, leave the court alone. Leave it at 9. Democrats have been trying to talk Justice Breyer into retiring so that President Biden can name a replacement. Breyer is one of, if not the oldest member of the court now after the passing of Ruth Bader Ginsburg. And the so-called conservatives on the court are now young men and women who are likely to be on the court for a long time to come. There are 2 younger women, I should say, on the court as well, who happen to be the other 2 liberal members of the court. But it's unlikely that Biden will have the opportunity to name a replacement if Breyer remains on the court, if Breyer does. And if Biden or the Democrats are ousted from the White House or the Senate changes in 2022, in 2024, if a Republican president takes over, it's a whole new ballgame again. This is why the Democrats are trying to make hay while the sun shines. They're trying to do everything they possibly can to get their agenda through, but it's going to require some help. In any event, they want to name a replacement. They want Biden to name a replacement for Breyer, and a younger person, obviously, so they'll have a chance at maintaining numbers with respect to the so-called liberal side of the court. Structural alteration by the perception of political influence, Breyer said just a few days ago, can only feed that perception, further eroding the trust. There can be no shortcuts to it, said Breyer. Now, that pretty much threw a wrench in the machinery, because he is a sitting liberal justice on the court, and he has been consistently a liberal justice on the court. He knows well what the Democrats are trying to do, and he knows well what the future of the court will look like if they don't succeed. And then the late judicial icon, Justice Ruth Bader Ginsburg, had weighed in 2019 in an interview on NPR when she said 9 seems to be a good number. It's been that way for a long time. She said, I think it was a bad idea when Franklin Roosevelt tried to pack the court. And basically, what she was saying is what all who oppose, whether Republican or Democrat, whether conservative or liberal, all who oppose court packing, and that is that the Supreme Court's independence would forever be lost if the numbers of the court were changed by packing the court as opposed to replacing, in the ordinary course, vacancies that occur on the court. Now, when you got that much negativism coming from people you would expect would be your supporters, looks like an uphill battle for this issue. Looks like it's going to be a difficult process for Democrats to get this thing through. In fact, the media, pundits, are saying that chances are slim to none that court packing is going to occur. Good news for the Republicans, I suppose. But the biggest concern is that if they continue to push this, the initial report from early polls today, after they came out with the description of the bill, the 2-page bill, very negative. The American people, many of whom don't understand how the court process works, nevertheless don't like the idea of essentially stacking the deck when you play the poker game. Politics being what it is, the Democrats can be understood to want to try to do this to save their agenda. But the bottom line is, odds are it's not going to be favorable. The latest attempt to pack the United States Supreme Court, I think, will fail just as it did when Franklin Roosevelt attempted it in 1937. And that could mean serious problems for the agenda of the Democratic Party going forward with the Biden administration, which has only been in office for a few months. So whether or not packing the court actually occurs, I think the odds are against it, decidedly against it. But you should know what the issue is all about and analyze what people are saying, especially analyze the rhetoric around the Merrick Garner nomination by President Obama back in 2016, and the difference between that and the Amy Coney Barrett appointment in 2020, because they're going to try to conflate those two together as being the very same sort of thing and tell you that they stole the seat that Garland should have had. Well, but that's not the case. That's not the case. The Senate rules are the Senate rules, and when the Democrats run the Senate, they change the rules their way. When the Republicans run the Senate, they change the rules their way. That's always been the case. And then, of course, anyone who is left holding the bag is always upset about it. So goes politics. And politics, as I mentioned, is a central part of the selection of justices to the United States Supreme Court. Well, that's it for today. I'll see you in a couple of weeks, and we'll have another issue to talk about at that time. I'm Mike Fitzsimmons, and I thank you for watching.
Thanks for tuning in to this edition of For Critical Thinkers. Join Mike Fitzsimmons twice each month for a chance to share your views about important issues that affect our lives. Stay tuned to Spokane Talks for